Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, we are back in the studio with attorney Jeff Roberts, who now has offices both in Murray and up in Hopkinsville here in Kentucky. So, Jeff, welcome back. Today's going to be an interesting topic. Why should you actually hire an attorney?
Good afternoon, Jim. How are you?
Buddy, I'm doing fine. It's always good to sit down with you and you take me to school on this most of the time. So I really do enjoy this because, I mean, there's a lot of information that I get from you that not only is good for my own knowledge, but, it's like anybody else. You family members ask you questions, and at least, I get to go to school for free here. So I kind of enjoy this. So let's kind of talk about this. If you're in a car wreck, in the state of Kentucky, you're not required to hire an attorney. I mean, you can handle it on your own, and a lot of people do, unfortunately. Today we're really just going to focus on why that's not always the best idea.
Yes, and I get that question a lot, and that's the reason I thought that might be a good topic for us to discuss. And I have people come in, and as I mentioned before, you can come talk to me. Initial evaluation is going to be free of charge. So if you have a question on whether you need an attorney or anything of that nature, and it's over a type of case that I handle, you can come in, sit down, and talk with me, and then make your decision at that point. But the reason that people need an attorney in a regard to a car accident case,
and this could also be a motorcycle accident, this could be a truck collision,
collision, motorcycle, any type of motor vehicle collision in Kentucky. The reason they need an attorney that handles those type of cases, whether it's me or another attorney that handles those cases on a regular basis, is because you can do things that end up costing you money and can cost you significantly if you don't do things correctly. And when I'm talking to clients or potential clients, some of the times they're not aware of the pitfalls that can occur if you try to represent yourself in this case. And the first pitfall that people don't realize that can be very, very costly is when you're injured in a car wreck, if your health insurance pays the medical bills associated with that, then they are entitled, that health insurance is entitled to be reimbursed what they've paid. Very, very few. Matter of fact, I don't remember the last time I saw a policy that did not require them to be reimbursed if a third person was responsible in a negligence type action.
So, in layman's terms, what are we kind of talking about here?
Well, let's. And I like examples because I learn more from an example than I do from somebody giving me technical talk. So if you've got Anthem Blue Cross Blue Shield health insurance and you've been to Murray Calloway County Hospital or in Hopkinsville Jenny Stewart Medical Center before, they've got your health insurance information. So if you're in a car wreck and you go to either of those hospitals to the emergency room, that bill may be sent to your health insurance as a matter of course. And while there is, as we've talked about in other episodes, there's what's called PIP coverage, personal injury protection coverage, that will take care of your medical bills and your lost wages up to a certain dollar figure. The bill may go to the health insurance first. So let's say you go to the emergency room, they do a CAT scan, and the medical bill is $9,000. Health insurance pays $6,000 of that medical bill. And then the insurance company comes and says they paid the property damage already at what you thought was fair value. Okay. Then they come in and say, well, because you did have an injury in this, we don't think you were that injured, so we think that your claim is worth $8,000. And you say, well, I don't want to pay an attorney. I'll just take the $8,000 and then sign a release, and that release is going to have language in it that if anybody has any liens or subrogation interest, it's your responsibility to pay them because every release from an insurance company has that language. Car insurance company has that language in it.
And this is where it gets sticky.
That's where it gets sticky. And you sign that release, then Anthem comes back And even if you sign the release, it doesn't have that. You're probably getting sticky too, but you're not going to find that type of release. But then Anthem comes in and sends you a letter. Was this a result of a car accident, a work injury, slip and fall, any type of thing like that? And then you are obligated to fill that out, send it back in, saying this was a car accident. Then they send you a bill, say you owe us $6,000. You've settled with them. We're entitled to the $6,000 we paid to Murray Calloway County Hospital, Jenny Stewart Medical Center. We're entitled to that $6,000 back. And if you spent that $8,000, it doesn't matter. You're on the hook to pay Anthem back $6,000 in that setting. And it can be times where and unfortunately I've had this cases where the medical expenses far exceeded the amount of coverage that was available, because in Kentucky and every other state, when you purchase insurance, you purchase a set dollar figure of insurance called policy limits. And so if the policy limits are $25,000, which is minimum for liability coverage in Kentucky, and your medical bills are $40,000, if you don't deal with that, what your insurance paid $40,000, if you don't deal with that up front, the health insurance could come back and say they get all that 25 and potentially say, we think you could have got more money, so we shouldn't have paid any of this. Now, I don't know that they'd go very far trying to get more than what you recovered. I know Medicaid has tried to do that at one time, and it didn't go very well, but that was federal law. I don't think it would go very far from that standpoint, but you don't want to have to worry about it anyway.
Right. Why take a fine?
But you don't want them to get everything either. And if you deal with it ahead of time, and I've gotten insurance companies to waive significant amounts in the past when that's been the situation. So.
But again, that's because you do this on a daily basis. You know how to negotiate. You've been doing it for the last 30 years. You know kind of what's available, what typically isn't going to be available. You know how to ask the right questions.
Right.
And that's where I think a lot of people they hear, well, lawyers might be expensive. I don't want to necessarily pay the lawyer on top of all of this. Lawyer's probably going to potentially save you a lot of money because they, again, know how to handle the case properly.
Right. And, what I hear is, and not all adjusters or claims representatives do this, but I've heard had clients come in and say, the claims representative said this is the most that they're ever going to pay. Why would you ever give a lawyer 1/3 of the of this amount? And I've talked to other attorneys who've found the same thing, and 99% of the time, the insurance company gets a letter from me and the offer goes up then.
Right.
And that's, or, even before they make an offer, they will say, if you want to go see a lawyer and give 1/3 of what we pay you to them, that's your choice, or you can deal with me. And people think, well, I'll just deal with him and not do that.
He seems nice.
Yeah, he seems nice, or she seems nice, and they don't. That person is not an attorney. They can't give you legal advice. They're not an attorney, and they're not going to tell you, oh, by the way, your health insurance may come in and ask for a large chunk of this money back. So, that's one of the main hurdles or problems with pursuing the claim on your own is there may be some other people out there who want to share in that piece of pie that you're that you're getting from the insurance company, and if you don't deal with that before you resolve the claim, everybody that's coming in to get a piece of that pie, it's going to come out of what that's going into your pocket. From that and can eat it up quite a bit to where there's very, very little left, if anything left. The other aspect that comes into play is, and we've talked about underinsured motorist coverage before, and I just mentioned a few minutes ago that policy limits can affect how much you can recover in a claim. In Kentucky, you are most likely going to have underinsured motorist coverage on your own personal policy, which underinsured motorist, for those who haven't listened to the other one, is basically coverage that says if I'm in an accident and the at-fault person's insurance limits aren't enough to cover all of my damages, then my own insurance will cover damages above the policy limits of the at-fault party up to whatever my total damages are, or what policy limits I have in underinsured motorist coverage.
And a lot of people really get squeamish about that. Well, I don't want to file that claim because then my rates go up. Well, you're already paying for that.
You're paying for it, and then your rates don't go up or should not go up. There's an administrative regulation that says rates don't go up for pursuing underinsured motorist claims. It's because you weren't at fault. You weren't at fault in causing that accident, so your rates should not be affected by pursuing an underinsured motorist case.
But for a lot of people, that's money that's sitting out there that they may think, well, I shouldn't pursue that. Yeah, actually, you should. Again, it's a contract between you and your own insurance carrier, and you've been paying the premium on it.
Yeah, you either pursue the claim or drop the coverage, because
Right,
why
right.
pay a premium for coverage you're not going to get?
Right.
When I say that, I'm being somewhat tongue-in-cheek in that regard, because you need that coverage and you need to pursue that claim. That's usually some of the cheapest coverage that you're getting because from that standpoint, because it's not mandatory coverage. They have to offer it to you, but you don't have to take it. So they usually price that to where you want to, where it's reasonable for you to take it. Whereas the mandatory coverage you don't have a choice on is usually higher priced. From that, so you want the underinsured motorist coverage on your policy, and you want to have good limits on that underinsured motorist policy. From that standpoint, and I've talked to clients about that, and and I've had clients come back in and their rates go up slightly because of cost of living, and they say, well, I didn't think my rates were going to go up because of this, and then, well, your rates went up $10. It wasn't because of this; it's because your rates would have went up $10 anyway. It's cost of living.
Right.
Wasn't the accident that caused that, but. Your rates went up $10 here. I got you $50,000 in this coverage. That covers a lot of $10 of increase in rates for over a year's time period.
Right.
But where it comes in and where the problem can be is if your damages are, and I'm just going to use figures, but let's say your damages are $450,000. You've got $100,000 medical, significant lost wages, significant pain and suffering, $450,000 total damages, and liability limits are $25,000, and you have.
In other words, is it $25,000 that the negligent driver had on
Yes.
his or her policy? So they're driving around with state minimum coverage.
Right, they're driving around with state minimum coverage. That fault person has $25,000 liability,
And that's
coverage.
all there is.
That's all there is. They have no assets. The car is, they don't even own the car. That they got a banknote on the car, and so there's nothing else to get other than the insurance policy limits. And you look at that and say, well, okay, they've got $25,000 limits. Insurance company knows this claim is well over $25,000. They're offering me the $25,000 policy limits. I'm going to take that $25,000 policy limits, and then I'll go talk to a lawyer. Problem is, if you don't, in Kentucky, in other states, but Kentucky, because that's the one I practice in, if whenever you, before you take the policy limits and sign the release for the at-fault party, if you don't give the underinsured insurance company notice of that settlement and give them the opportunity to substitute the payment, so that because when you sign that releases your insurance carrier's claim against that at-fault driver as well. So if you release their claim without them knowing about it ahead of time and having the opportunity to protect themselves, then you've released your underinsured motorist claim as well, and you no longer have a claim against your insurance for that coverage that you've paid for. So you've got the $25,000, and you saved a little bit of money maybe in attorney fees, but you cost yourself the $100,000 underinsured motorist claim, and you didn't take into account the medical bill. So now the $25,000 and a chunk of that's going back to your health insurance because you already used up the PIP coverage, which was $10,000, and so the other medical bills was paid by your insurance company, and now
Now they want to come back around and get part of your 25.
They're wanting to come back and get part of your 25, and you can't go against the underinsured carrier at that point, and you're the one left holding the bag in that setting.
Yeah.
When the other person was at fault, but because things weren't done legally proper, to protect you, then you can end up losing big time.
And friends, if you're listening to this and you're going, "Wow, I'm not," this is complicated. That's reality. The law is complicated. Injury law is very complicated, and it's one of those things that you can do this on your own, but why would you? Jeff, do you want to talk about a contingency fee? I know we want to get to a couple of other things here real quick in this topic, but talk about a contingency fee, because injury law is different from other kinds of legal services and other kinds of practices in that it doesn't cost me anything to hire you.
Correct. And a contingency fee is basically that my fee is contingent upon recovery. So if there is no recovery in the case, there is no attorney fee. And then in a contingency fee, the fee is a percentage of what the recovery is. The way I work on car accident cases, whether it's motorcycle, car, truck, semi-truck collisions, whatever, I work, well, semi-truck can be a little different, but as a general rule, my attorney fee is going to be 1/3 of the recovery. That's what my attorney fee is. Some attorneys have gone up to a greater attorney fee of 40% in those type of cases. I have not increased the fee in those cases. 30 or 1/3 of the recovery, I think, is a reasonable fee, and that's what I charge in there. And it's more than just the recovery of the funds. It's also making sure the client gets to keep all of those funds, making sure we get everything there is to get, making sure the health insurance gets back as little as possible. And all of that comes into play on that 1/3 attorney fee from that perspective. So the client, it does not have to, when they come in to see me, when they hire me and they sign the retainer agreement, they're not paying me a penny at that point in time. I get paid when I put money in my client's pocket. That's when I get paid as well in these cases. And also the other side is I advance the litigation expenses. That's the cost that I incur in pursuing the claim on the client's behalf, cost of medical records, deposition, testimony, expert witness fees. If I have to have accident reconstructionist, those type of costs, all of that is also contingent upon recovery. I advance that cost as it's incurring, so you don't have to pay expenses as the case is going on. And the expenses are also contingent upon recovery. So if I am successful, I get paid, reimburse my expenses at the end of the case as well from there, but the client's not out anything until the end of the case.
Right. And at the same time, and I know you kind of said this, but this is a lot of people are trying to figure out, well, where's the loophole there? Even if you were unsuccessful in securing a settlement or a verdict on behalf of the client, and you forwarded all of those expenses, you don't pass that on to the client either.
No, it's the reimbursement of the expenses is contingent upon recovery. So if there is no recovery, then I don't charge expenses back to the client. And that kind of all comes back to, all of us have had car trouble at some point in time, and at least I know in the past, I've taken a car in to get a problem fixed, get the car back, pay the bill, and still have the same problem because what they fixed wasn't really what the problem was.
Right.
And not blaming the mechanic, they thought they were fixing the problem, but I still had the same problem, had to go back and get something else done to it. And I never liked having to pay that bill when the problem wasn't fixed, but I still had to pay that bill. And I decided a long time ago what I was going to do when I practiced law was if I am not successful in the case, if I don't fix my client's problem to the extent I can, obviously I can't take away the injury. If I could, that's what I would be doing. But fixing the client's problem to the best I can under the legal system that we have in the United States. If I don't do that, then I'm not going to charge the client for that. If I do that, then I am going to charge the client. And that's the reason I work on a contingency fee basis. It just kind of goes back to that same concept.
Well, and that kind of summarizes for me a lot of how you've chosen to practice law over the past 30 years. I mean, it's straightforward stuff here. Your Google reviews, all these other reviews out on social media talk about how personable you are, how you explain things, easily to people, and people just enjoy working with you. And I think again that comes by because you kind of get a sense for who you are as a person. Yeah, you're going to potentially be my attorney, but I like you as a person because you have those principles in the forefront of how you do business. And I just think it makes it easy, to contact you and to feel at ease, when I walk through the door here.
Well, I hope my clients are comfortable talking with me, and I try to make clients comfortable when they're in here talking with me about any type of issue from that standpoint. And to me, it kind of comes back to, and I won't say I always live up to this standard, but I try to. And that's, you should treat people the way you want to be treated. That's the way I was raised. That's a value that my parents instilled in me as a very young child, and I saw my grandparents model that as well, and that has been instilled in me. And I tried to do that with my clients. I tried to treat the clients the way I would want to be treated, and frankly, if I I didn't want to be charged when my car the problem didn't get fixed. And I don't want to have that situation, I'm not going to do that to my clients.
Well, I love it. We have it all over the website. It's small town service, big city results, and I like that. That really kind of encapsulates that entire philosophy.
That's what I try to provide: small town service and big city results. Yes,
I enjoy that. Jeff, let's come back to the conversation here as we kind of wrap up. We're in the final few minutes here. And the question is why I really actually need to hire an attorney, or why I should hire an attorney if I've been in a car wreck. And we want to talk a little bit about not handling that PIP insurance correctly. And you want to, again, explain PIP real quickly so people understand what no fault really means? And yeah.
PIP, or, and a lot of people here in Kentucky is a no-fault state, and really there's only one aspect of Kentucky motor vehicle law that's a no-fault, and that's the PIP. And what PIP, or personal injury protection, and it goes by a lot of different names: no-fault coverage, PIP coverage, or personal injury protection coverage, BRB, or basic reparations benefits, or added reparations benefits. A lot of different names for basically the exact same type of coverage. And that coverage is coverage that will pay your medical bills, lost wages, and a few other things if you're involved in a motor vehicle collision. Up to the limits that you have. The minimum they can write in Kentucky is $10,000. You can have added PIP or added reparations benefits above that.
But if you're a licensed driver in the state of Kentucky, you automatically have $10,000 worth of coverage there to help with medical and some lost wages, basically.
If you have insurance.
Right. I'm sorry, I said licensed. I meant insured driver. Yeah. Right. And what's interesting about that, though, in the state of Kentucky at least, that $10,000 covers you as the driver, but it also covers it's $10,000 for your passenger, $10,000 for the passenger in the backseat, $10,000 for the other passenger.
Every person in the vehicle has whatever the limits are. If it's $10,000, then that's it. If you purchased additional coverage, then that can apply to them as well. And so you've got that coverage there, and you can use that coverage in a way to maximize the recovery. And attorneys who do this for a living know how to do that. And you can direct the coverage. Kentucky allows the injured party to direct the coverage, or the injured party's attorney to direct the coverage. Which basically means you can say this gets paid, this doesn't get paid, don't pay anything. At this point in time, reserve it all for lost wages for right now. There are various things that can be done to lessen the burden on the injured party, injured person, while they're initially recovering from the injury, but also to maximize the recovery on the backside of it. The no-fault or PIP coverage will pay 100% of the medical bill that's billed to them. That's the only coverage I know of that does that. And so you can reserve that and then use that to pay other things and end up maximizing, because reimburse the health insurance that's paid the bill and basically extend that PIP to where you're paying more than $10,000 of medical bills with that $10,000 of coverage.
Right. It almost seems kind of silly the way it works, but people hear it's automatic. But again, there's a process and there's a little bit of a strategy to how you do this.
Yeah.
Because Jeff, as an attorney, you can sometimes negotiate with a hospital to take a lesser. Okay, here's a $20,000 bill for this procedure. Well, that's fine, but you may be able to say, hey, would you take 12?
Exactly. And
I may not think about that as a car wreck victim or the family member. I may not think about even asking about something like that. I got a bill. I got to get it paid.
Yeah, exactly. And I've got a couple of cases that have been in the office recently that are kind of a prime example. One, the person came to me very early on in the process. And they hadn't even filed the application for the PIP coverage. So I helped them fill out the application, sent the application in with the letter saying we're reserving 100% of this PIP. Don't pay anything until we tell you to pay that. The other person came in later in the process, and the emergency room hospital sent their bills in. There was a CT scan. Two CT scans of a couple different parts of their body. Later on, had an MRI. All of that got sent to PIP, and the $10,000 of PIP coverage was already exhausted before I got involved for that. The other client had very similar treatment. To both clients had very similar treatment from that standpoint, and the one who had came to me before they ever started using the PIP. Essentially, what I did was use that $10,000 to reimburse health insurance, which the health insurance took $20,000 medical bills, paid it off with $10,000 of payments. I reimbursed the $10,000 to the health insurance, wiped out $20,000 of medical bills with that $10,000 PIP, and the other person had $20,000 of medical bills. PIP paid $10,000, health insurance paid $7,000 of the other $10,000, and then that $7,000 went back to the health insurance out of the recovery that the client had. If they'd come to me earlier, they'd had $7,000 more in their pocket at the end of the day from that. And that's where an attorney knowing what to do and how to do it can make sure that does it day in, day out. Because frankly, I know I've talked to some attorneys who don't do personal injury work, car wrecks a lot, that weren't doing that. And when I talked to them, I said, start doing it this way, and your clients will be better off from that standpoint. And frankly, when I first started practicing, I would have been, luckily I practiced with someone who did this a lot, who trained me. And so I had the benefit of that knowledge from somebody else who'd been there. And I try to share this benefit, my knowledge, what little I have with others that ask anyway from that standpoint, and happy to do so. But that's where having an attorney that does personal injury work, does car accidents day in, day out, will actually put money in your pocket at the end of the day. And it's just, to me, come in and talk to me, free of charge, come in and talk to me about your car wreck initially. If for some reason I'm not the attorney for you, that's fine. I don't have a problem with that. If I'm not the attorney for you, or if you think, all right, well, I think I can handle it on my own and you want to do that, fine. Come in and get the information, talk with me, learn what your rights are, and then you can make the decision. You can make at least a somewhat informed decision from that standpoint, and don't, make sure when you resolve it, if you do without an attorney, have the health insurance aspect lined out, have the underinsured coverage taken care of and protected, because the claims representative, the insurance adjuster, they're not representing you. And I'm not going to say they're trying to cause you any problems whatsoever, but their goal is to wrap that claim up in the best way possible for their company and for their insured, not for you. And so you need somebody in your corner fighting for you as well.
Jeff, I think that makes a lot of sense. And again, I want to remind people, we talked about it at the outset of this episode that, you're located here in Murray, Kentucky, in Calloway County, but you've also got the new office up there in Hopkinsville in Christian County, and you're servicing really Western Kentucky at large. I mean, you have a long history of taking cases well outside of Callaway County.
Yes. In fact, I don't know why, but not too long ago, I did look at that, and the majority of my clients actually live outside of Callaway County. And again, I don't have and it may have been when I was looking at if I wanted to go to Hopkinsville and I was looking at how many clients I had up in that area. I can't recall. But I did look at it, the communities where my clients live. And, I have a lot of clients in Callaway County, but better than 50%, I think it's around 65% are actually outside of Callaway County. And I have clients as far away as Louisville, Jefferson County. At this point in time, I've represented them as far away as northern Kentucky, up in the Covington area, Whitesville over in eastern Kentucky. And so I handle cases all over the state. If you've got a personal injury case, call me up, and if I can't take the case on for whatever reason, I will certainly put you in touch with someone who I think can do you a good job. If I can take the case on, I'll do you the best job I can.
Well, and we'll wrap it up with that statement, but I do want to remind people, Jeff also, as part of his legal practice here, does workers' compensation claims and Social Security disability claims as well. So he's one of those hybrids that actually can do personal injury, car wrecks, the lot. He could do the workers' comp and the Social Security. And there's not that many firms out there that handle all three of those areas. So, again, that's another nice aspect of dealing with the Roberts Law Office.
Yeah, and just because of some KBA ethics rules, any attorney licensed in Kentucky can handle those cases. Very few attorneys handle all three of those as a routine basis. I'm one of the ones who does that.
Outstanding.
Yeah.
Jeff, I appreciate your time. I know you're busy. And friends, if you've been listening to us for the last half hour or so, I want to thank you for your time as well. We'll be back in about 2 weeks. In the meantime, feel free to check out more information about Jeff on jeffrobertslaw.com, or you can check him out on Facebook. And we will be back here in, like I said, about 2 weeks. Jeff, thanks again, guy.
Thank you.
Yep, take care. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.